Hello, everyone, and welcome to Uncivil Law. For today's case, we reveal the truth that it is, in fact, legal to flip off a cop. Not necessarily advisable, but legal. And this was most recently reaffirmed in the case of State of North Carolina versus Sean Patrick Ellis. This is a decision from the Supreme Court of North Carolina. In this case, Mr. Ellis flipped off the cops. The cops were sad. And he was arrested and charged. And he is appealing that no, you can't actually do this. And the state of North Carolina is like, yes, you can't actually do this. It is, in fact, legal to flip off the cops. Not necessarily a good idea, but legal. And we're going to confirm that once again. Let's get started with this. Around lunchtime on the 9th of January 2017, a few days after a significant snowstorm, Trooper Paul Stevens of the North Carolina State Highway Patrol was flagged down in Stanley County by a stranded motorist who had run out of gas. Temperatures were below freezing, and Trooper Stevens stopped to help. That was very thoughtful. Trooper Stevens called for an officer with the Albemarle Police Department to help him render aid to the motorist. Officer Adam Torres arrived at the scene. Both Trooper Stevens and Officer Torres had the blue lights activated while the patrol cars were positioned on the side of the road, which, makes perfect sense because we want to be visible so that people won't run into us. But yes, so we were flagged down by a motorist who has run out of gas. And we're being thoughtful police officers. We're going to render aid to this stranded motorist. So, good job by the police. And then some other random guy comes along and decides he wants to get involved. So let's turn to random guy. While assisting this stranded motorist out of the goodness of our hearts, Trooper Stevens turned his attention to another car traveling on the roadway. Defendant, a passenger in a small white SUV, had his arm out the window and was making a back and forth waving motion with his hand. As Trooper Stevens turned to look towards the car, defendant's gesture changed from a waving motion to a pumping up and down motion with the middle finger. Yeah. So this random guy, these officers are just having a bad day. They stop to help the stranded motorist. They put on lights to protect themselves, and this random guy, presumably thinking that this is a traffic stop or whatever, decides to flip off the police, even though they were trying to help a stranded motorist. Man, sometimes it just does not pay to be a good guy. But then the way they reacted to that was not so great. But yes, this random motorist is now flipping off the cop. That's good stuff. Believing that the defendant was committing a crime of disorderly conduct. No, that's not how this works. No. Trooper Stevens got in his patrol car to pursue and stop the SUV. No, it is not disorderly conduct to have contempt for the police. You can flip off the police. It is not obstruction. It is not contempt. It is none of these things. And yes, police do this all the time. It's like, oh, I'm at my butt hurt. I'm gonna use a criminal sanction that I have. This is not what this is for. No. Trooper Stevens pursued the vehicle for half a mile with his blue light still activated. Trooper Stevens did not observe the SUV breaking any laws during this half-mile pursuit, so good on the SUV. And the SUV pulled over the side of the road without an incident. When Trooper Stevens asked the driver and the defendant for identification, they both initially refused. You can't really do that. You have to provide identification. Yeah, there's many statutes that make it a requirement to identify, but yeah. After about a minute, the driver provided identification, but the defendant still forbid. So the defendant is not the driver. The defendant is a passenger. He's refusing to provide ID. You still have to identify yourself, but yeah. Trooper Stevens took the defendant to the patrol car, and eventually the defendant agreed to provide name and date of birth, which, is normally what you have to do. Trooper Stevens issued a defendant citation for resisting, delaying, or obstructing the officer under the code. At the trial court, defendant moved to suppress the testimony, arguing there's no reasonable basis to justify the stop, which there really isn't. The trial court orally denied the motion, finding there was reasonable suspicion for the stop. So the trial court said, we have reasonable suspicion for the stop, so no. Defendant gave notice that he intended to appeal, and then pled guilty to resisting, delaying, or obstruction. So he gave notice of intent to appeal and has pled guilty pending appeal. So we're going to plead guilty and we're going to argue the law. Okay, fine. At the Court of Appeals, defendant again argued the stop was not valid because Trooper Stevens lacked reasonable suspicion. Defendant was engaged in disorderly conduct. The state argued the stop fell within the community caretaking exception to the Fourth Amendment. Okay, no, wow, no. All right, so this community caretaking exception to the Fourth Amendment. Let's talk a little bit about that. The community caretaking exception is kind of in this nebulous world of we're not quite sure if it's a thing or not at this point because the court has never definitively said it is a thing or not, but let's talk a little bit about what it is. And there are definitely courts that have rejected it. So what is the community caretaking exception? The community caretaking exception is there might be needs for the police to do certain things where there's not probable cause of a crime. So to give a classic scenario, your employer, you haven't shown up for a couple days, and you're normally a really, really predictable worker. And maybe that your employer was aware that you had some health problems or something, because you have a relationship with your employer, and you haven't shown up for a couple days. So this guy is concerned about you and whether or not you're healthy. So he wants for the police to do a welfare check to make sure you're okay. And so the police come to your home, and they see they can't find anyone, and they decide to enter the home. Now, maybe the door was open, maybe it's cracked, maybe it's unlocked, maybe it's locked, but maybe they decide to enter the home, and they find you, dead, or find you whatever on the ground. Or they come to a place, they come to a different scenario. They happen to drive by a place, and they see a house with the door open, and they want to look in. So they decide to go to the door and look into the open door. This is all perfectly fine. It's in plain view, and things look like they're in a complete state of mess. Now, is that sufficient in and of itself to say that there's been a crime? Maybe, maybe not. But maybe they should use the community caretaking exception to take a closer look, because maybe this is a burglary, or maybe it's just a really unkempt person. We're not sure. So these are the kind of things that they're talking about, this community caretaking exception. And so we're not quite sure if this is a thing or not. The only time it's ever been upheld has really been in cars. It's never been upheld to a home. So they're arguing that the community caretaking exception, which to the extent it exists, does apply to cars, exists here. So this is a little bit of a nebulous field of law. This is a little bit thing where the courts are not quite really sure, but that's what they're trying to argue, this community caretaking exception. We didn't have probable cause to arrest. Because all he did was flip us off. So we don't have probable cause, but we have a community caretaking exception. Okay, what exactly is that community caretaking exception? We needed to intervene because why? We were concerned about what? I don't know, but that's what they're arguing. We were concerned, and we need to check on the concern. Okay. So that was their argument. And therefore, Trooper Stevens did not need a reasonable suspicion to justify the stop. So yeah, we don't even need the reasonable suspicion. We're on some other grounds completely. The Court of Appeals unanimously decided the community caretaking exception did not apply to these facts. Which, it doesn't. If it exists, which again, dubious, but yeah, it doesn't apply to these facts. Instead, the majority of the Court of Appeals concluded there was reasonable suspicion for the stop and concluded it was okay. So yeah, they concluded there wasn't community caretaking, but that's okay. There was reasonable suspicion. So you did meet Terry. So you don't need this community caretaking exception. We're going to tell you that you met your standard under Terry versus Ohio. You have reasonable suspicion, so you can conduct the stop under Terry versus Ohio. Court of Appeals isn't having any of it either. Okay, so on to the Supreme Court of North Carolina. What does the Supreme Court of North Carolina have to say about this? The defendant appeals to this court on the basis of a dissenting opinion from the Court of Appeals. In the brief here, the state acknowledges its sole argument in the Court of Appeals involved the community caretaking exception, and the court unanimously rejected that argument. In fact, the state agrees that the specific articulable facts do not establish a reasonable suspicion. Because of that, we reverse. So even though the Court of Appeals said you had reasonable suspicion, the government's like, no, we really didn't. We have a community caretaking exception though, so that's good. And the Supreme Court of North Carolina is like, no, none of these things. No, you don't have any of these things. We reverse. So let's discuss the law that does or does not apply. Refusing to identify oneself to a police officer during a valid stop may constitute a violation of law. You do have to identify yourself, yes. We've held that failure to provide information about identity during a lawful pursuit can constitute resistance, delay, or obstruction. Now, to be clear here, you have to identify yourself, not present identification. Because if you're not the driver, there's no obligation to have identity on you. You're not obligated to have a wallet. You're not obligated to have an identity card. You're not obligated to have these things. But as a general rule, you are required to identify yourself. And what is that? Name, date of birth, address, that would be fine. So yes, as a general rule, you are required to identify yourself. Not necessarily present ID. But yes, that is a rule that's generally true in many places. The primary issue before us is whether or not the stop is valid. So yes, If you refuse to identify yourself during the lawful stop, that may be a problem. But that's the predicate. Was it a lawful stop? Let's find out. The United States Supreme Court has long held the Fourth Amendment permits a police officer to conduct a brief investigatory stop of an individual based on reasonable suspicion that an individual is involved in a criminal activity. That would be Terry versus Ohio and all the wonderful cases that flowed from that. The Fourth Amendment permits brief investigatory stops when the law enforcement officer has a particularized and objective basis for suspecting the person of criminal activity. The standard takes into account the totality of the circumstances, the whole picture. Although a mere hunch does not create a suspicion, the level of suspicion standard required is considerably less than a wrongdoing, a preponderance of evidence, and obviously less needed for probable cause. Yeah, it's a lot less, yes, but it's something. As the court has explained, the stop must be based on specific and articulable facts, as well as rational inferences from those facts, as viewed through the eyes of a reasonable, cautious officer guided by experience and training. Therefore, when a criminal defendant files a motion to suppress, the trial court can deny the motion only if it concludes, after considering the totality of the circumstances, the officer possessed a reasonable suspicion to justify the stop. Okay. The trial court concluded there was reasonable suspicion to justify the stop, and the Court of Appeals agreed. But reviewing the record before us from first principles, we're unable to conclude there's specific and articulable facts known to the officer, which would have led the officer to suspect the defendant was engaged in disorderly conduct. Disorderly conduct is a public disturbance intentionally caused by any person who makes or use any utterance, gesture, display, or abusive language which is intended and plainly likely to provoke a violent retaliation and thereby cause a breach of a peace. So fighting words, basically, in short. The following facts can be inferred from the testimony. The defendant was waving from the passenger window of an SUV and a few seconds later began to gesture with his middle finger. Trooper Stevens did not know whether the defendant's gesture was directed at him or another driver, and after pursuing the vehicle for half a mile, he did not observe any violations or other behavior. We conclude from these facts alone, it's insufficient to provide a reasonable suspicion the defendant was engaged in disorderly conduct. The fact that Trooper was unsure of whether the defendant's gesture may have been directed at another vehicle does not, on its own, provide suspicion the defendant intended to, or was likely to provide a violent reaction from another driver. So he wasn't trying to flip off another driver, he was trying to flip off you. So this wasn't like a road rage thing or a potential road rage thing. This was a I don't like police thing. He's allowed to not like police. Likewise, the mere fact that the defendant's gesture changed from waving to flipping the bird is insufficient to conclude the defendant's conduct was likely to cause a breach of the peace. Yes, you're allowed to wave at the police and you're allowed to flip them off. Again, not necessarily advisable, but legal. Based on the facts of this record, we're unable to infer that by gesturing with his middle finger, defendant was likely to provoke a violent reaction that would cause a breach of the peace. In conclusion, there's no reasonable suspicion of disorderly conduct to justify the stop, and it was error for the trial court to deny the motion to suppress. We therefore reverse the Court of Appeals and remand this court for further proceedings, reversed and remanded. So this is a decision from the Supreme Court of the state of North Carolina, in the state of North Carolina versus Sean Patrick Ellis. In this case, we learn Mr. Ellis, a passenger in a car, seeing police assist a broken down motorist, decided to flip off the police. Probably not advisable, but legal. And the police then tracked him down and pulled him over and tried to penalize him. And the Supreme Court of North Carolina says, no, you can't do that. It is, in fact, legal to flip off the police. Again, not advisable because you're probably going to have a bad time. But, whether or not it's legal, it's legal. Whether or not it's a good idea, well, I suppose I leave that to your conscience. But yes, it is legal to say F the police. It is legal to say F the draft, as we learned from Cohen versus California. It is legal to disparage the government. It is legal to say mean things to the police. So, yes, you can flip the bird off at the police in North Carolina. And that's the end of the coverage of this case.